channel, and today I just want to give some sort of detailed overview, if I may say it is detailed, or should I say the summary of the decision of the court in the case of Salomon and Salomon. So the case of Salomon and Salomon is a landmark case as far as company law is concerned. It is the locus classicus case for the proposition of the law that once a company has been incorporated means the company has been registered, the company automatically has what we call separate legal personality, that is SLP. And the fulcrum of this is that once you incorporate a company, the company is a distinct legal person, which means that you see the members of the company, the shareholders, they are distinct legal persons and they are different from the company. So just as they have their own rights and liabilities, the company also has its own rights and liabilities. The company has its own assets, and the asset of the company is not the asset of the shareholders. So the case of Salomon and Salomon stands for that particular proposition, such that when you deal with the company and you feel like you have any right against the company, yet the law says that what you should then bring a claim against the company, not against the members of the company. And if you feel like maybe there is any liability that accrues from the company, then you should not be reaching out to the members of the company. Instead, you should be bringing an action against the company, because the company is a separate legal personality. And it can also be the other way around, in the sense that just as you can sue the company can also sue you in its own right, in its own name. That is what the case of Salomon and Salomon represents. Of course, the case of Salomon and Salomon has been applied in a plethora of our cases, and also you know that there are now exceptions to the rule that when you have a company, it's a separate legal personality, in the sense that there are times where the court would say that, oh, the company is only using its SLP as some sort of facade or some sort of mask. So in a way, that's what they are actually individuals, human persons, natural individuals that are controlling the company, and they are the ones that are perpetrating either a fraud or they are trying to frustrate a right that another individual has. And in that particular circumstance, the law says that you may have to lift the veil of incorporation, or you may have to pierce the veil of incorporation. And what this means is that you are simply going to take away the separate legal personality of the company, and you are going to see those individuals. So which means that you are going to interpose the company and the individual, and that, you know, that distinction that exists between the company and the individual will no longer exist. So you are going to treat the company as the individual and the individual as the company. And this was one thing that you know, the creditors in and the liquidator in the case of Salomon and Salomon attempted to do. They wanted to rip Salomon off. They wanted to chew him and spit him away because they felt like, since he was the controller of the company, they felt like he was only using the company as some sort of alias. He was only using the company as some sort of facade, and that there was really no company, because Salomon was the company. So it is very important to understand this, because by the time we begin to talk about lifting the veil or piercing the veil of incorporation, you begin to see that there are some Nigerian cases where they attempted to actually apply the case of Salomon and Salomon, but they didn't really apply it correctly. The law says when you lift or you pierce the veil of incorporation, right from Salomon and Salomon, Salomon says the moment you are validly constituted a company, the company stands alone, and then the members also stand alone. So the court said that Salomon stood alone from Salomon Company Limited, and that also stood alone. So when you now claim that you want to pierce the veil of incorporation, or you want to lift the veil of incorporation, it means that you are saying that you want to interpose, that is, you want to join the company and the other member in such a way that they become one. So meaning that there is no distinction, there is nothing like a separate legal personality. So when you lift the veil or you pierce the veil, it means you are saying that there is nothing like a company existing. Those that are controlling the company, they are really the company, and there is nothing like a company. Because there are times that you hear the court saying that they want to pierce or lift the veil of incorporation, and then they will say that they are doing so because you're using the company as your agent. Now the thing is this: if you are using the company as an agent, so let's say that you claim that, okay, maybe Salomon used the company as an agent, and you are now claiming that, okay, in order to hold Salomon responsible, you have to pierce or lift the veil, and that one way to pierce or lift the veil is to see the company as you know, Salomon's agent, or in any other case. Now the thing is that for you to have an agency relationship, the law says there must be two distinctive individuals, two independent individuals, the principal and the agent. And when you are lifting the veil, it is very important to understand the law cannot see two individuals, two entities. No, lifting the veil means that you are taking away the separate legal personality of the company. So the company does not have its own life. That is what you are saying, and you are treating the individual behind it as more or less like the company. So you cannot claim to be lifting the veil by way of agency, because when you still say that the company is an agent, you're still recognizing the fact that the company on its own exists. So in that circumstance, you are not lifting the veil. You are just simply going ahead to identify those that are more or less like the corporates, those that are culpable, without necessarily involving the company. And that was what the court tried to do in the case of Prest versus Petrodel, saying that you can have the consummate doctrine and you can have the evasion doctrine. Now, in the consummate doctrine, you are not lifting the veil because you are still recognizing that the company still exists. You are only going behind the company to identify the culprit. And then in the evasion principle, it means that you are going to interpose the company and the individual. It says that the individual the individual is guilty of some wrong, but then he has involved the company. And in order for you to be able to hold the individual, you have to join the company with the individual in such a way that when you now claim to pierce or to lift the veil, it means you are saying there is nothing like a separate legal personality. We can only see one person, and it is you. And that company does not exist because you have only used it as some sort of sham. So this is very, very important. And that is why we say that you cannot understand lifting or piercing the veil of incorporation if you do not fully have a full grasp of the decision, the rationale, and the principles that were laid down in the case of Salomon and Solomon. And having said this, it is then important at this very juncture that we then try to consider the fact of Solomon and Solomon. So the fact of Solomon and Solomon was simply that, Solomon used to own a sole proprietorship. You understand? He was a sole proprietor. He had a one-man business where he used to sell shoes and the likes like that. And then later on, having run the business for about 30 years, he decided that he wanted to then turn the sole proprietorship into a company. And like we said, before you can turn an existing business into a company, then you have to go incorporate the company. Now, when you want to incorporate the company, the only authority that you have to listen to, or you have to look at, is actually a statute. So he needed to look at the Companies Act. And then in the Companies Act, he found out that yes, when you check section 6 of the company, it says the Companies Act, it says that before you can claim to incorporate or create a company, you must have at least 7 or more persons. So which means that only one person could not create a company during Solomon era. 2, 3 could not. You have to be from 7 upward. And then if you check section 8 of the Companies Act, it also provided that no subscriber shall take less than a single share. So after you got 7 individuals, they also have to take shares in the company, and they cannot take below 1. They can take 2, they can take 3, but they cannot take below 1. So that was what Solomon felt, and he felt like, okay, since he has a wife, he has 4 sons, and he has 1 daughter, automatically the entire family makes up the 7 members. So what he did was he called the other members of the family, and then he said, let us incorporate this business, let us make it into a company. And they all agreed. And so the 7 the other members, including Solomon, making it 7, then they subscribed to shares. And since they said they must not have anything less than 1 share, so what Solomon did was he gave each of them one share. So collectively they all owned 6 shares, while Solomon held at about 20,000 shares. And then it's also important for you to understand that when they incorporated the company as Salomon Company Limited. Yeah, they said they incorporated the company with the name Aaron Salomon Company Limited, with limited liability by shares and having a nominal capital of £40,000 divided into 40,000 shares of £1 each. So Salomon got 20,000 shares, while 6 shares were then held by his wife. Then it's very important to also point out at this juncture that at the very beginning, it was the intention of the parties, that is Solomon and his other members of the family, to retain the business in their own hands. it was more or less to be some sort of family business, and they didn't want to actually permit any outsider to acquire an interest in the company. But then later on, within a year, you understand that the company was not really doing well, and so it got to a point where the company could not pay the interest upon the debentures of Broderick. So Broderick instituted the action to enforce the security against the assets of the company, and this made a liquidation order to be given. So when the liquidation order was to be given, you have to understand that Salomon sold his business, his one-man business, that is where the sole proprietorship. He sold it to the company. So when he sold it to the company was supposed to to also pay him, but then the company could not pay him, so the company gave him some sort of debentures. Now, debenture is a secured loan. What debenture means is that when you have creditors, people that the company is owing money, whether banks that give out loans and all, it can either be secured creditors or it can be unsecured creditors. So secured creditors are the ones that more or less they know that even if a liquidation order is given, their interest is protected in such a way that when at least the assets of the company could probably defray the company's debt, and where the asset of the company is insufficient, maybe there is one guarantee or one other thing that would at least be something that would pay their debt. But the unsecured creditors, they are not secured. So if the company's asset is not enough, then they are on their own. So when you have a debenture, it's a secured loan in the sense that when they want to start paying creditors, because you hold a debenture, it means that they will give you priority. And so Salomon was more or less a secured creditor in a company that he had an overwhelming and inundating or controlling interest in. So when it was then time to be paying the creditors, the company felt that the assets of the company, if they should use it to pay Broderick's debt and the interest, they said it will remain a balance of about £1,055, and Salomon was already claiming it as beneficial owner of the debentures that he had. So then the law, they looked at it and felt that if this is sustained, then there will be no funds that will be left for payment of other unsecured creditors, because for the unsecured creditors, their debt amounted to at about £7,733, and so the liquidator then counterclaimed and said no, that there were the agreements that the company and Salomon had in July 20 and that of August 2 said it should be rescinded, and that the debentures that he gave Salomon should be cancelled, and so that Salomon should even pay the company all the money that the company had paid to him. So what they were basically saying is that yes, there was an agreement for Salomon to transfer his former business to the company, and he would transfer it at a particular price, and because the company could not pay all the price, the company gave him certain amount of money, but then they paid the rest in the venture. So when the liquidators felt like, by the time they pay Salomon the debentures, there will be no money that is from the assets of the company that will be left to pay the other creditors, the other unsecured creditors. So they started saying, no, another agreement is null and void and should be invalidated and set aside, such that they were saying that even all the money that the company has paid Salomon needs to repay it, because according to them, they feel like Salomon is the company and the company is the Salomon. So one of their grounds for also holding same or contending so was that they said that the price paid by the company it exceeded the real value of Salomon's business, the business he used to own, and his assets for at about £8,200. And they said that the arrangements that was made by Salomon for the formation of the company, they said it was simply a fraud upon the creditors of the company, and they said there was actually no board of directors that was appointed, because the board of directors actually consisted entirely of Salomon, so there was no independent board. But then the courts actually saw that at the end of the day, evidence showed, because Emmanuel Salomon, one of Salomon's sons, was able to also show that before Salomon transferred his business to the company, before he sold the business to the company, it was clear that he was doing fine. The business was solvent and that the business was prosperous then. So the court felt that, well, So what do you mean by what? Fraud. So the business was prosperous and the likes. And even the liquidator himself also admitted at a point that the business was sound, as at the time it was transferred. So then the court was then like, okay, the business was sound. So how is that what? A fraud? And even at the Court of Appeal level, you hear that even Vaughan Williams, one of the judges, also said that of course it was very clear that there wasn't really any fraud, so to say, like that, because it felt like, okay, yes, you could probably sell your business to a company, and then you can sell it at an exorbitant price. And if the price had been too exorbitant, perhaps that may be a ground for suspecting that maybe there was a fraud. Although he concluded that the price that Salomon sold it to the company was somewhat exorbitant, but the High Court really, the House of Lord, the judges really didn't really feel like it was an exorbitant price. But even Vaughan Williams at the Court of Appeal level the trial court also felt like even if you claim that the price was somewhat exorbitant and high, as long as the Salomon was open, you understand, as long as he did not hide any facts to the company, then how can you say that there is a fraud? You understand? How can you say that there is fraud? And so the court had to distinguish between the case of Elanga versus New Sombrero Phosphate, Elanga versus New Sombrero Phosphate, because in Elanga and New Sombrero Phosphate, the court also established that when a member wants to more or less transfer his business to a company in which is actually a shareholder, that he is in a fiduciary or relationship with the company, and flowing from that fiduciary relationship, the law casts certain obligations on him, in the sense that he has to open up and he has to more or less tell the company everything about the business. And so, but the court said that in Elanga versus New Sombrero, what happened was that in that case, it was very clear that the vendor acted fraudulently when he sold his business to the company without opening up to the directors and the shareholders. But then the court said in Salomon's case here that the agreement of July 20 was actually known to the members, and it was also approved by the company and the shareholders. So Salomon did not hide anything from the company, and the company was even doing well. It was not like maybe the company was not doing well and they misrepresented certain facts to the company. Then he could have said that, well, he defrauded the company. If that had been a ground, then Salomon should probably be seen as the same as the company. But in this circumstance, the court said, no, this is what we just saw, in the sense that there was a company and there was Aaron Salomon, and Aaron Salomon contracted the company. And the law says that if you incorporate a company, the company is a separate legal person, and being a separate legal person means that you can enter into a contract just like every other natural person can. So nothing stops a company from contracting with a member of the company. Only just that when a member of the company wants to enter into a contract with the company, he needs to understand that he stands in a fiduciary or position with the company. So but then as it was then, the court said, okay, in that particular instance, you cannot really claim that there was a fraud. Then there was also the fact that the company then argued that, well, they said the company was formed by Aaron Salomon, and that the debentures of £10,000 were issued in order that Aaron Salomon can carry on the business and take all the profits without risk to himself, and also that the company was the mere nominee and agent of the appellant. So they were saying that, well, Aaron Salomon used the company as a dummy, as his agent, and that if he use the company as his agent, like every other agency relationship, then he needs to indemnify the agent. So they were saying that, well, he just did it so that he would acquire all the profit, and then he will not be able to suffer any loss. But then you hear that Lord Watson was saying it that, well, they really that naturally you can simply see a company as carrying on business on behalf of its members, but that is not enough to say that the company serves as the members or agent. And the court said the whole essence of incorporating a company, especially with limited liability, is because you want to apply your capital, but you want your interest to be protected and your liability to be restricted to the amount or the quantum of money that you have more or less advanced to the company. And that the fact that you now hold the largest shares, you are holding the largest shares so that when it is time for them to share profit, then you take the largest profit. But that does not diminish the fact that there is also a risk And the risk is that if the company should go bankrupt, you're at least going to still lose the certain amount that you have invested in the company. So being a controller or having overwhelming or interest in the company does not still take away that risk. And that was the response that Lord Watson gave to that, and it was a rejoinder to that claim by the company. But you must always understand that the creditors and the liquidator, they both succeeded at the trial court, and they also succeeded at the court of appeal. So at the trial court, the court held that well that Aaron Solomon was using the company as his agent, and since he was using the company as his agent, that automatically there really isn't any difference between Aaron Solomon and the company. But then at the court of appeal reached the same decision with the high court, the trial court. But then they said no. Aaron Solomon did not use the company as his agent. Now instead, the company serves as Salomon's trustee. But then when the matter got to the high court, the House of Lords rather, and the House of Lords interrogated and investigated some of their rationale for the decision, and said the high court, Vaughan Williams was like, well, that he didn't constitute what the company in line with the act. And at the court of appeal, he held it, saying that, well, you constituted the company as mere dummies to do the very thing that the act forbidden. He said the constitution of the company, as in when he was setting up the company, that it was not in line with the true meaning and intent of the act. But then at the House of Lords, the House of Lords judges were like, okay, what exactly do you mean by the true meaning and intent of the act? That if we are going to get the true meaning and intent of the act, then it should be from the act itself. And as they looked at the act, they saw that yes, it said 7 members. This guy constituted it was 7 members. And that section 8 said, well, each shareholder must not have less than 1 share. And each of them did not have less than 1 share. That there is nowhere in the act where the act said that the shareholders cannot be family members. There is nowhere in the act where the act forbidded an individual having overwhelming share. In fact, Lord Eschel rather was even saying that if the drafters of the act had actually applied their minds to the fact that a particular circumstance like this could have arisen, and they didn't want such a thing where somebody would now have a domineering control of the company, then they probably would have set up some sort of minimum share that they would hold. So maybe they would have said that, okay, well, no particular individual can own beyond a particular amount of shares. But at the House of Lords, the judges were like, well, it is the duty of the courts to interpret the law, not to import into the law that which cannot be found in the law. And so the court then said, what exactly did they mean by it set it up to not in line with the true meaning and intent of the act. And another thing was that the court said that at the high court, at the trial court, and also at the court of appeal, that the court found it very difficult to see the company as a real thing. Like at the end of the day, you are more or less saying that they did not properly constitute the company. So if you did not properly constitute the company, then the company cannot enjoy separate legal personality, such that Aaron Solomon will be the company and the company will be Aaron Solomon. But then at the end of the day, you are still also holding at the court of appeal, at the high court, that the same company that was not properly constituted is an agent. So you see that, and then at the court of appeal, said the same company that was not properly constituted was also the trustee. So the court at the House of Lords was like, if you say something was not done in line with the true meaning and intent of the act, it automatically says that what the whole incorporation was invalid. And if the whole incorporation is invalid, we know that it's incorporation that makes the company to exist. So meaning that the company was not existing. So if the company was not existing, how then is the company serving as another party's agent? Because for there to be an agency, then there must be 2 parties. The thing must exist. If you say the company was a trustee, and then yet the company was not properly constituted, it is more or less saying that there was no company, but yet you are also still saying that, okay, the company that never existed was still serving in an individual capacity as trustee. So we said, it's some sort of contradistinction, because you cannot say that a company exists and then still say that what a company does not exist. So at the House of Lords, they said the company exists because the company was properly constituted in line with what the act. And since the company exists, it automatically means that Aaron Solomon was what? A different person and then the company is also what, a different person. And then the court said nothing stops Aaron Salomon from contracting with the company because both of them are separate individuals. And then the court said that, well, when you have a limited company, the law does not say that you, the creditors, you must trust what, a limited company. So if you do not trust a limited company, you should look for a way to protect yourself, because by the company being limited, you automatically know that, okay, they are telling you that what, as far as what the liability of the members is concerned, then automatically it is only the assets of the company that will defray what, that will defray your debt. And so you would decide whether to go ahead and transact with the company or not. And the court even said it at the House of Debt level that the creditors that were just complaining and the likes like that, that they could have actually checked the register of shares and they would have seen that, oh, one individual held what, the overwhelming what, shares, and they would have also seen the old debenture that was transferred to Aaron Salomon. So if they had actually investigated that, they would have been able to decide whether to still contract with the company or not to contract with the company. And the court at the House of Lords said that the law casts what, an obligation on those who want to, third parties who want to deal with the company to at least make such investigation. And that your apathy, because you know the liquidators that they argued and say, well, most third parties that want to trade with the company, they hardly check the register. And then the court said, well, their apathy towards, you know, whether the nature of the company, the operation of the company is not enough to then cast obligations on the members of the company beyond that which the law provides for. So you find that as they were making attempts to reach Aaron Salomon, the court was saying that no, you dealt with what? You dealt with the company. You didn't deal with Aaron Salomon. So as you are dealing with the company, now that there are now challenges or problems, then it should be you and the company. You cannot reach Aaron Salomon, because Aaron Salomon is different and the company is also a different personality. And then you have to also but then understand that the court also held that yes, the court admitted that proceedings which are permitted by the Act may be so used by the members of a limited company as to constitute a fraud upon others to whom they in consequence incur personal liability. In this case, the fraud is found to have been committed by the appellant against the creditors of the company, but it is clear that if so, though he may have been its originator and the only person who took benefit from it, he could not have done any one of those things taken together to set constitute his fraud without the consent and without the consent of the other shareholders. He said the liquidator cannot sue its members for redress against a fraud which was committed by the company itself and all its shareholders. So simply the court was more or less saying that at the end of the day, this is not to say that just because you have followed the Act, just because the Act said, okay, fine, this is how to incorporate a company, and you have incorporated the company, that it does not mean that you cannot still use that, using the law more of as an engine of fraud. That it is possible for a company to actually follow the Act, incorporate the company, and yet they are going to use the company for fraud. And so this is one area where you begin to understand how fraud serves as an exception to the whole separate legal personality of the of a company. How fraud becomes one of the grounds upon which the veil of the company can be lifted. So even when you are properly set up the company and you are using the company as fraud, the law says that then in that particular instance, the company will be seen as you and you also will be seen as the company. This was actually stated in the case of Salomon and Salomon. And so you have to always understand that fraud is one ground for holding what. So, but then the court said that it does not find anything wrong in one individual holding the controlling share, because the Court of Appeal kept saying, well, that even though there were 7 shareholders, 7 members, that the company was a one-man company. Yeah, the Court of Appeal said the company was a one-man company. But Lord Eschel at the House of Lords level responded by saying that, well, that it has often happened that a business that is transferred to a joint stock company at times may be the property of 3 or 4 persons only, and that the other subscribers of the memo may even be clerks or other persons who possess little or no interest only in the concern. So it was like he's unable to see how it can be lawful for 3 or 4 or 5 or 6 persons to form a company for the purpose of employing their capital in trading with the benefit of limited liability, and not for one person to do so provided in each case that the requirements of the statute have been complied with and the company has been validly constituted. So he's saying that the whole argument of, okay, a company is a one-man company. Yes, it's a one-man company, or at least you know that you have a company on its own and then you have that one man. So Lord Esther was basically saying that, well, it has always been there at times when you set up a company, you see that the whole interest of the company may be in the hands of few members of the company. And that, well, there's nothing wrong with that as long as they have followed what the law says, in the sense that other members own particular shares, and when they are owning the shares, they own them independently, not that they are serving as the nominees of the controller of the company. Because if they are serving as the nominee of the controller of the company, then it's as if it's the only person that owns what the whole share. So that means you have not followed what the act says. So he's saying that if 3 or more persons can actually have controlling share, and since you still say that the company exists because they follow the law, then there's nothing wrong with having one person actually holding the controlling share. And then perhaps this also brings to our attention the new development in our own corporate regime, because with CAMA 2020 we now understand that we cannot have a one-man company. So we can have a one-man company. So we can have a company where it's just someone, maybe just Ori David, but then that does not stop the company from existing as a corporate legal person. So that is, and the court also at the House of Lords, Lord Esther was saying that, you see, the thing is, you cannot continue to say because you owned the business before that was a maybe some sort of one-man business or a partnership, and then you convert it to a company that you're now the company's trust, the company is your trustee, or you're the company's trustee. No, he said that it used to be that all those banking concerns and all, and insurance concerns that were more or less partnerships before, that they have turned their concerns, that is their businesses, into companies. And he said if that is the case, then it means that we should always look at all of them as trustees and all. And so that is not so. And he said that the statute does not forbid that a single person can have controlling shares. The statute does not forbid that. And so the court said in this particular case, Salomon sold the business. Salomon was open. The business was doing fine. He did not defraud the company. The company knew what they wanted to get. They paid and they agreed to it. They paid him. The one they could not pay him, they gave him the debenture. The law did not say forbid them from giving a member the debenture. You, the creditors, the law provides that you could have gone ahead to investigate. You could have checked the register of debentures. You would have seen that they gave a member debenture. You could have checked the register of shares. You would have seen that, okay, there's a controlling member, someone who has the highest for shares. And if you have done all of this, it could have alerted you, and you could have known whether to proceed to deal with the company. And when you want to proceed to deal with the company, you could have known how to actually protect yourself. And then if you decided not to do this, then you cannot now start to turn around and start claiming that, okay, because the shares the majority interest of the company is in one person's hand, and that person